Welcome to the plenary session that's opening this virtual fall CLE program for the criminal justice section of the American Bar Association. We are going to address the rule of law. The title is The Future of Criminal Justice, but we've asked our speakers to be broad in their view, that what we've come to realize, particularly in the Black Lives Matter era we're in, that justice doesn't break down so simply between civil and criminal, that there is no justice in the criminal justice system if the civil justice system fails, and vice versa. So we have three speakers today. We have Robert Gray, Jr., former president of the American Bar Association, great civil rights lawyer. We have the Honorable Bernice, United States Court of Appeals judge for the Sixth Circuit, very recently a chair of the criminal justice section, and a spirit that guides our section at all times. And my colleague from the George Washington University Law School, Ralph Steinhardt, one of the great international and human rights lawyers and professors in the country. And we are going to begin with former ABA President Robert Gray, Jr. Who has to unmute.
Okay, is that better? Thank you, Stephen, and thank you for the invitation to participate in this very important discussion about the rule of law, sponsored by the Criminal Justice Section. Stephen asked me to talk about the rule of law as it pertains to some of the other work that I'm doing that relates to the Legal Services Corporation. And while that is very civil in nature, it is an underpinning to the rule of law and gives us a 360-degree look at both criminal justice and civil justice. I thought I would begin by giving us a quick update on the Legal Services Corporation as an entity. Legal Services is a grant-making organization, the single largest funder of civil legal aid for low-income Americans in the nation. And it operates as an independent group, as a 501c3 corporation. It was funded in 1974 as one of the last acts of the Nixon administration to help provide equal access to our system of justice and to provide high quality legal assistance to those who would be otherwise unable to afford adequate legal counsel. Now, LSC is a bipartisan board of directors, 11 members appointed by the president, confirmed by the Senate. The president has 6 appointments, and the minority leader in the Senate has 5, subject to the acceptance by the president and confirmation by the Senate. Funded largely by Congress, LSC distributes 93% of its federal appropriation to 132 legal aid organizations with 880 offices in every state and territory. Legal services grantees, those who receive the fundings, offer legal services to households with incomes at or below the federal poverty level. These individuals and families face a wide variety of legal problems: domestic violence, child custody, support wrongful evictions, mortgage foreclosures, and we also support veterans. We issued a justice gap report recently. And in that report, we found that 58.5 million low-income Americans were eligible for LSC-funded legal aid. The Justice Gap report found that 86% of the civil legal problems reported by low-income Americans receive inadequate or no legal help. Other studies have found that low-income Americans seek help for only about 20% of their civil legal problems. the National Center for State Court reports that in almost 75% of civil cases in state courts, one or both parties are unrepresented. And with the pandemic thrust upon us, nearly all of our experts have said that they expect significant increases in the requests for such legal services, particularly in eviction, foreclosure, consumer debt, and domestic issues. The pandemic has also wrought financial problems on the legal services community. With the Federal Reserve lowering rates to zero, it has pretty much decimated the IOLTA programs that we depend on for about $65 million, more than 5% of most legal services budgets. Legal service grantees are also facing cuts in state budgets, sparked by the drop in general revenue and sharp cut in filing fees and other contributions that are the foundation for those contributions. Here's the good news. LSC's annual funding for Congress has risen modestly over the last few years and now stands at $440 million. The bipartisan board has requested funding this year for the year of 2022 of $1.8 billion. And that was agreed upon by both Republican and Democratic appointees to the board. The appreciation and the bipartisan support of this board in understanding the importance of helping low-income Americans is also significant as we look at what it means to establishing respect for our justice system and the rule of law. LSC also oversees a technology grant-funded program. Started in 2000, this program has distributed nearly $70 million to 750 projects of LSC grantees. The grant recipients use this funding to create innovative ways to serve clients, strengthen program capacity, and support the work of pro bono attorneys. LSC is also partnering in the development of online statewide access to Justice Portal to direct individuals to the most appropriate civil legal assistance. The board of LSC also formed a 60-person pro bono task force that made significant improvements to the private attorney involvement rule that governs our work with pro bono attorneys. The task force also called for the creation of a pro bono innovation fund that was first funded by Congress in 2014 to the tune of $2.5 million. That has increased also to $4.5 million. The pro bono fund has awarded more than 100 grants of nearly $30 million. These projects involve collaborations with many partners, including bar-sponsored volunteer lawyers programs, healthcare providers, technology providers, and law schools. LSC also embarked upon a privately funded initiative that has created a rural summer legal corps where dozens of law students now serve legal aid providers in rural communities each summer. These funds have also provided innovative support training and leadership skills in the civil legal aid area, the development of a legal aid curriculum for public librarians, who often are the first people low-income Americans consult when seeking legal help, toolkit and online guide that enable our grantees to better use client outcomes data in order to enhance self-assessments. Access to justice is a core principle of the rule of law. Failure to provide such access to our legal system undermines Americans' confidence in the fairness of our justice system and breaks faith with the founding values of our nation and threatens the rule of law. As the director of the Office of Economic Opportunity, Sergeant Shriver said at the ABA's annual meeting in 1965, the extension of legal services to the poor is only a means of a more universal end, one we both share, the establishment of the rule of law. He added, it is that ordered quest for dignity, for justice, and for opportunity, which is the central concern of society today. Our work is more as important today as it was when it was started, and continues to be a safety net for all Americans who are of low income and face the daunting problem of access to our justice system. I hope this helps frame the discussion for today in the need for promoting the rule of law and the access to justice. And I thank you for this opportunity to share these thoughts with you.
Thank you, Robert. I should have mentioned when we started, and I'll mention now, that we have a chat function for those who are participating. And if folks have questions, if they put them in the chat function, eventually we'll try to get to them. But I wanted to ask you something, Robert, and then I hope Judge Donald, who's going to go next, could weigh in on this. It's somewhat ironic that most poor people with legal problems cannot get representation. I mean, despite all the good work the Legal Services Corporation has done, the only way you get a lawyer in the United States if you're poor is commit a crime. And then if you're an indigent, we have to give you a lawyer, and then maybe that lawyer will be able to help you deal with whatever frustrations and problems that are out there. I mean, when you were president of the ABA, you traveled the entire country, and you saw basically, you heard people talking about these access to justice issues. And I wondered, do you think that the inability of people to get access to justice, do you think that fuels some of the violence we have, some of the angry responses that we get that ultimately result in crime?
I do, Stephen. I mean, I think that part of being a citizen of this country is believing that you have an equal chance to participate in the way in which our society conducts its business. And that business of having access to the courts, having access to a lawyer, is a fundamental right. And we have talked about the Gideon rule being applied to civil justice. That time is upon us, and it is something that we ought to always consider as a part of forming the basis upon which we all have the opportunity to be represented and to have access to our justice system. It goes without saying that the resolution of dispute in a way that provides dignity to those who are in that dispute promotes the rule of law. It gives us confidence that we will be treated fairly. And it is an important foundation to the founding principles of this country that are framed in the preamble to the Constitution. That justice is one of those rights that is guaranteed to all Americans.
Thank you, Robert. Judge Donald, it's time for me to turn to you, and I wanted to, in addition to what else you will say, you've sat as a state judge, you've been a federal district judge, and now, of course, you're at the Court of Appeals, but when you were at the trial court, you had a chance to see the real people who came before you. and you had a chance to learn how they ended up, particularly on the criminal side, how they ended up where they ended up. And I wondered whether you have a view about the inability of people to feel that, as Robert said, they're equal, that they have a fair shot at most of the things in this country, whether that does in fact contribute to the criminal justice problems we have, crime rates and the like. No one better able to speak to that on this panel than you. But you have.
I want to thank you first, Steve, for inviting me, and I want to thank Robert for setting the stage for that. I certainly agree or concur in all of his comments. I will say there's another issue, though, and that is the ability of people to even understand initially that they have a legal issue for which they need to get access. I think the ABA did some work and some studies, and they showed that many people did not recognize that they had a legal issue until they were already in crises. And because they couldn't afford lawyers, then they would turn to their minister, their barber, their neighbor, whomever, do that. But I think that there is an issue that really is an overarching issue that drives to criminality. When you're talking about these civil issues that so many times drain any measure of resources and sometimes of dignity that people have, they're left in their minds with few options. And I think there is a connection. For example, Dr. Carrie Ressler, who's now at Harvard, talked about studying communities of high density, high poverty, high violence, and talked about the connections to criminal activity. Now, not everyone who lives in such a community is going to end up in the criminal legal system, but many will. And he talked about that from a neuroscience standpoint, saying that there are also environmental and mental health issues that impinge and impact upon that situation that have a disproportionate effect and a disproportionate influence on driving people into certain conduct. And I'm not in any way trying to absolve personal responsibility, but I want to back up and start way back. You've heard me mention that there was an organization many decades ago called the National Conference of Christians and Jews. And they were interested in people's assessment, their belief in whether or not they could go into one of America's courts, civil or criminal, and reasonably expect to get a fair shake and have a fair outcome based simply on the merits of their case. Overwhelmingly, African Americans reported that they did not believe they would be treated fairly in court, civil or criminal. They did not believe that they were likely to get a fair outcome in court, civil or criminal. That was followed next by then characterized as Hispanics, I suppose now the Latinx community. And after that, Asian Americans. Whites were the only group that consistently said, I believe that I can get a fair shake and a fair outcome in court, be it civil or criminal. Now, Native Americans were not surveyed in that particular study. And that speaks sort of to the problem of invisibility or whatever, but they were not. Now, more recently, still, I guess over a decade ago, I think the Pew Research Center replicated that study and included Native Americans. And really, the needle in terms of the expectations had not changed. African Americans still say there are disparities in the system that keep me from reasonably getting a fair shake and a fair outcome. So I want to talk about some of those things now. I got my master's at Duke University in the last several years, and I use as my thesis something called When the Rule of Law Breaks Down. And I used as a case study the 1866 Memphis Massacre. What I was interested in is whether we have really, as Americans, a shared definition of the term rule of law. And I don't believe we do. I believe that people who are living at the margins have a different view. I think we experience and internalize that based on many of our societal circumstances. And so for that reason, I believe the following things will impact how we see it going forward. First of all, I think we have to be concerned about perceived and real disparities in the justice outcomes on the criminal side. We know that we have vastly disparate numbers of African Americans who are incarcerated in jails and prisons. When they're sentenced, they're serving far longer times than their counterparts. Many of them are going in very young and are there for the bulk of their useful life. We now know that implicit and explicit bias drives some of that. And we in the criminal justice system obviously are working hard to educate and address some of that. We have got to confront the fact that the bias is real and that it can have negative and pernicious effects on the justice process. Those things, Steve, lead, I believe, to a lack of confidence ultimately in the judiciary as an institution. And what I mean is that just like water on stone, if we keep having that same replication of a phenomenon, it erodes away the underpinning of that institution as a neutral institution that gives everybody a fair shake based on the law as applied to the facts in their case, and that everyone can expect to go in, be treated with dignity and respect, and have their case fairly adjudicated. I also believe that those biases and other things will cause people going forward to start to view the courts through an ideological and a partisan political lens if we don't tamp down some of what people are hearing and internalizing today. People honestly believe that the appointing president of a judge can in some way impact how that judge dispenses justice, how that judge views their case, how that judge makes his or her decision. And that is a dangerous, dangerous notion, because judges must be viewed as neutrals, and judges must hold themselves and do their work as neutrals without regard to any other arbitrary factor. I said that all of those things, I think, can lead to a lessening of the respect that the judiciary as an institution is held. I also think that there are real and imminent threats to the judiciary based on some of the rising issues and concerns that are manifesting in society today. We know that over the past decade, we've had a number of, especially federal judges, who have been injured or killed. There are increasing threats to state judges. And we know that the bulk of this work that we're talking about actually occurs at the state level. Judges have been threatened not just with physical harm, but they've been threatened with removal from the bench if they decide cases in a manner that the community doesn't agree with. There has been legislation in some states passed to be able to what they call slap judges down if judges are not acting in conformity with community norms or views. And that too undermines and erodes the traditional independence of the judiciary. Attacks from the legislative and the executive branch on the judiciary can be very harmful and can also help to undermine the stability and the independence of that co-equal and third branch. I would also say, going back to some of the other factors, while we as judges have to interpret and apply the law that is passed by the legislature, I think we do have to understand the role that these other issues like poverty and mental health and all of that plays in the overall larger society that drives such huge numbers into the criminal legal system. We can't pretend that it doesn't exist. Now, it may be that we can't factor that into our decision making, but I think we have to be aware that that is one of the factors. I think another factor that impacts the system, and this is something that is bound up with the things I said before about the implicit biases, about legislative actions, about executive views, and this whole notion of fees and fines, which gets right back to the poverty to which I referred. And I know that the American Bar Association Criminal Justice Section has been really looking at this issue, has passed resolutions on fines and fees that keeps poor people oftentimes locked up for far longer than they should be, that causes poor people to make decisions that may not be in their best interest, to plead guilty to things that they may otherwise have a right to trial in. But in order to get back to their families, they plead guilty because they can't afford the fees and fines. Those kinds of things, to my view, are really antithetical to a rule of law that treats all people the same. Because are we saying that we have one standard for the rich and prosperous and another standard for those who are poor? I don't think that's what our rule of law stands for, and I don't think it should tolerate that. I have to say one final thing, because I know we in the criminal justice section are an organization of prosecutors and defense attorneys, academics, judges, and other people, police chiefs. But I have to say that when I talk about implicit bias, I am talking about all of the stakeholders, and that includes judges. We're worried about and working on trying to educate judges so that they become aware of their biases and learn how to negotiate those so that it doesn't interfere with justice outcomes. But I think we also have to work with prosecutors on charge bias, because I think that Congress and I guess the executive have really, in the federal system at least, moved judges from their logical place as being a fulcrum in that process and placed prosecutors as the center of power in the criminal legal system. And so, whereas judges must hold ourselves accountable for our actions in protecting and upholding the rule of law, prosecutors must do the same, and defense attorneys must embrace their role and become aware and negotiate their biases so that all of us can try to get to a place where people not only experience the fullness and equality of justice, but that they perceive they have experienced it. And unless we can address those things, I think we have continued problems going forward. So those are my initial comments.
One question before I move this over to Professor Steinhardt, and that is, what was your reaction when you saw that the current administration said no more implicit bias training for federal workers?
You know, I thought that was most unfortunate. And while, and I know that's a huge blow, but I think that even with the administration saying that, that does not absolve us of finding ways to educate ourselves. Right now, there's such a rich body of literature and trainings that one can get. I hope that we will soon get back to a place where that training is no longer frowned upon or no longer abolished for federal workers. But while we're in that wasteland, people should not take it upon themselves that they cannot find ways to further their learning and examine biases that might be injurious to the justice system. So I was very disappointed, not just because I do implicit bias training, because I can't do it for a fee, but because I think we need that. You know, if I could just share one story that I share when I'm doing this training, and it goes to prosecution bias or charging bias. Two individuals coming into court charged under the federal statute of being a felon in possession of a firearm. African-American male, charged in an 8-count indictment, being a felon and having 8 weapons. Each weapon forms a separate count of the indictment. That person pleads guilty and is set off for sentencing. And I want you to know at the time that happened, every count of that indictment carried a special non-waivable assessment of $100. So this math is still the same. 8 times 100 will be $800. Later that same day, a young white male pleads guilty to being a felon in possession, 8 weapons, and all 8 weapons are subsumed in a single count. So there's a 1-count indictment with 8 weapons. Because it happened in the same day, I caught it and called the prosecutor down to say why. Because if you're looking at these things out through any lens, people who are looking at that are going to say somebody who's convicted of 8 counts is much more dangerous than somebody convicted of 1 count. And it has effects and impacts on people going forward. So that's just one example that's at the ready. But I do believe that we have lots of work to do, and we need that training. I don't believe that the person who probably did that was malicious in any way, but the outcome is still the same. And it causes people who live in one community to say, there's no justice, it's just us. We're treated more harshly, we're held more accountable, and we're going to come up always on the rough end of the prosecution angle.
So I am going to get to that. I just want to make one point, and we can go back to this later. And that is one of the most impressive things, I think, about justice in the United States is the way in which these state and federal judges have dismissed the challenges to the election. I honestly thought that there would be judges who were Republicans, for example, who would have been anxious to hear these cases. And they weren't. They called it, in every case that seemed to me, they called it fair. And that seems to me to be something that we need to notice and take account of. But let me turn my attention to my colleague, Ralph Steinhardt. As I introduce him, I can't help but tell you a little short story that my wife and I were dealing with an ill dog. So we were in 2 different parts of our house listening to National Public Radio. And there's this voice that was there talking about his father and role in the Manhattan Project, the atomic bomb, and how it helped him decide to change his religion. And it was about as moving a presentation I ever heard. And my wife agreed, and she said, "Who was that?" And I said, "I'm certain from the voice, that was my colleague, Ralph Steinhardt." And I then circulated to everyone on our faculty a link to that program, because I thought it was something everybody should have heard. And Ralph, I think that it also helps explain why it is he cares so deeply about not just justice in America, but justice throughout the world. And Ralph, we're experiencing things right now that when we used to hear about them in other countries, threats to people counting votes, threats to secretaries of state or their equivalent abroad, we think can't happen in the United States. But I mean, it turns out, whether we want to be or not, we're not isolated from the rest of the world. So I hope you'll talk about the rule of law, in a broader perspective, internationally.
Steve, thank you so much for those words, and it is one of the honors of my life to be your colleague. It is an honor, of course, to be invited to participate in this session, especially with these visionary hosts and these distinguished panelists. And I just want to thank everyone here for the opportunity to raise one person's voice in confronting and exploring the true meaning of the rule of law ideal in this country at this time. In his opening remarks, my distinguished colleague, Professor Salzberg, noted that the rule of law doesn't break down between civil and criminal law, something that President Gray picked up on beautifully. I guess I'm here for a few minutes to say that it also doesn't break down between domestic law and international law for the very reasons that Professor Salzberg just suggested, and that if some of the things that we are now seeing in a daily way in the United States were occurring in foreign countries, we would call it by its right name. We would call it racial discrimination. We would know what it was. We would know that it was a coup if we had people trying to control the the vote, trying to control the results, and trying to manipulate the judiciary to get those results. So it's an opportunity, I think, just to reflect, to get some perspective on where we are as a country and what the rule of law ideal is. I have to say that I'm struck by the fact that we are meeting to the day, the 75th anniversary of the opening of the Nuremberg Tribunal after World War II. It was on this day that the Allies opened the tribunal that would try 24 of the most important political and military leaders of the Third Reich. So it was 75 years ago tomorrow that U.S. Supreme Court Justice Robert H. Jackson opened that critical prosecution with this famous observation. I'm quoting him, that four great nations, flushed with victory and stung with injuries, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason, end quote. Well, this is not the time or the place to sort of survey the gap between what we might call the rosy view of Nuremberg and the skeptical view of Nuremberg. But I do agree with Scott Horton, who has written that the flickering candle that was lit at Nuremberg has developed into principles which form the heart of the international legal order. And I start here because it enables me to discuss the rule of law ideal from an international perspective and to draw out the perspectives, the insights that it offers into the current American experience. I suspect many people in this session will be familiar with the subsequent Nuremberg proceeding captioned the Justice Trial. The Justice Trial brought 9 officials from the German Ministry of Justice and 7 members of the judiciary who were charged with judicial murder and other atrocities, quoting, which they committed by destroying law and justice in Germany and then utilizing the emptied forms of legal process for the persecution, enslavement, and extermination on a large scale. The emptied forms of legal process. Those prosecutors knew that the principal defense of these jurists would be that they were simply following the law of their time and in their place, that they were adhering to the rule of law. How could they be guilty of violating the rule of law when they were enforcing it as it was given to them? And it was important that an international conception of the rule of law would trump the domestic Nazi-era rule of law. That was essential to a successful prosecution, and it worked. 10 of the lawyer defendants were found guilty, and it means, I think, that the rule of law has these crucial layers. Not all of them are consistent with one another. And it seems to me the Justice Trial, though it is remote in time, does allow us to reflect on the injustices that are done in the name of the rule of law. That's the point that I wish to make. That's what perspective, it seems to me, international law offers. That in pursuing the rule of law, it's no guarantee that the rule of law will actually be vindicated. And just as racism and white supremacy in America are not limited to the Klan or the Klan-adjacent organizations that we're now seeing proliferate, abuse of the rule of law ideal is not limited to Nazis. And those long ago proceedings show that we really basically misunderstand the rule of law ideal if we treat it as some simple, performative, rhetorical abstraction. To the contrary, international law now treats the rule of law as a deeply pragmatic and granular requirement. Pragmatic because the international community understands that war and national security crises tend to be human rights crises in their late stages. If you do not address injustice, then you do not achieve security. The United Nations is also quite clear now that the rule of law ideal is pragmatic in the way that it leads to development, economic development, that justice for women and girls is one of the primary ways of assuring that a state can develop fairly and effectively. And so this idea that the rule of law ideal properly understood is first of all complicated, and second of all, deeply, deeply pragmatic, as Professor Salzberg's question to President Gray suggested. The founder of the United Nations knew in their bones what has become a rallying cry on American streets, and that is no justice, no peace. That is a crucial pragmatic connection. I guess that enables me finally to make a closing appreciation of three American civil rights icons: Justice Ruth Bader Ginsburg, Congressman John Lewis, and Professor Drew Days. I think the death of Justice Ginsburg raised for many of us especially pointed concerns about the rule of law in this country in the future. But I think we can use not her death, but her life as a cautionary tale, warning us against thinking too simply about the rule of law ideal, and calling us as lawyers to practical action. Practical action, perhaps in the form of good trouble, as John Lewis put it. Now, I realize that Justice Ruth Bader Ginsburg was an opera fan, but I have a secret fantasy that she was also a jazz fan, a jazz aficionado, that she had in her collection a secret stash of John Coltrane and McCoy Tyner and Miles Davis and Bill Evans, with maybe a little Ornette Coleman thrown in. And the reason I favor this fantasy is not just because I am a failed jazz pianist myself, but because I think the law, when it's done right, is actually more like jazz than it is like arithmetic. That it has theme and variation. It has structure and spontaneity. To mix my metaphors, it has both roots and wings. And so everybody on this call knows that the practice of law has its obvious occasional drudgery and its more mechanical operations. But I also know that, especially in this section of the ABA, there's a profound degree of creativity in making the law work. So to me, it seems like a kind of jazz. For Ruth Bader Ginsburg and John Lewis, Drew Days, to have seen how the Constitution can be used to advance people who were not included in the Constitution in its original draft. Justice Ginsburg saw, I think, as a kind of jazz, that the 14th Amendment might be used to assure the rights of women and LGBTQ plus people. Something that may seem obvious now, but I don't think it was obvious when she thought of it. So that the theme here is the language of the amendment and its historical context, of course, but the variation is in making the law live up to its promise, right? That's where the improvisation came, and it worked, and it lasted. And what is the cautionary tale? And with this, I will close. What is the cautionary tale for the rule of law ideal? I think that she would recognize that there's this bumper sticker version of the rule of law ideal that puts it on a par with support pie at Thanksgiving. You can't disagree with it in the abstract. And I think she would say that that's exactly why we have to confront the uses to which the rule of law ideal has been put in our history and in our present in exactly the same way that the Nuremberg proceeding against the judges and the lawyers did in the Nazi era. And that, I think, is crucial and connects well with this entire session. The dominant set of ideas that holds this conference together, I think, has to be the proposition that the history of law and the history of racism in the United States are intimately connected. The arc of Ginsburg or Days or Lewis's work demonstrates that even apparently neutral principles and idealizations like the rule of law will mask power, specifically power in the form of racism, racial inequality, white supremacy, white privilege, so that the apparent neutrality in principle of equal protection or freedom of speech or the rights of private property has been characteristically compromised in application in ways that disadvantage people of color. So that there is this crucial disconnect, in my mind, between the orthodoxy that race ought to be or is irrelevant in the law and the historical reality that the law has been the dominant vehicle for enforcing white supremacy in the United States. And I'm not here talking about some highlight reel of famously racist decisions by American courts in the past, like Dred Scott or Plessy versus Ferguson or Korematsu versus United States. The fact that each of those decisions has been repudiated to some extent or overturned is, I think, often interpreted this is a symptom of white fragility. It is overinterpreted as a sign that race now plays no role in American law, or that incremental progress over the explicit forms of racism, that's enough success for 1 century. But I think we do, and the previous speakers have made a signal contribution just in this short time together, showing sort of tracking out the legal consequences of white supremacy. One more point, sorry. Quickly to be made about the life of these 3 people. A call to action in the face of apparent neutral ideas like the rule of law. And it is a lovely answer to the skeptics, especially postmodern critics of rights discourse. And here I take my leading from Professor Kimberly Crenshaw, who said, rights have been important. Continuing the quotation, they may have legitimated racial inequality, but they have also been the means by which oppressed groups have secured both entry as formal equals into the dominant order and the survival of their movement in the face of private and state repression, end quote. So this idea that the rule of law ideal can be challenged for its masking of power and also used to expand, if you will, the promise and the effectiveness of the law, that seems to me one of these 3 people's lasting legacies, and one that we are all challenged to pursue in the ways that the other panelists here and in some of the other sessions of this conference have shown in concrete detail. Thank you all very much.
That was great, Ralph. Thank you. One of my old professors used to talk about the normative power of the actual. And what he meant by that was that a lot of us tend to think that the world as we see it now is the way it's always been. And in fact, Ralph did a remarkable job of talking about race. And I would just suggest, and I want to ask Robert what his view about this is. I think that there are many people who look at the country now. We've had an African-American president. We now have a African-American vice president-elect who think that, well, you know, we're there. In fact, we haven't been very there for very long. I mean, when I started teaching, and you'll remember this, Robert, the University of Virginia, Farmington, the country club there, they wouldn't admit either African Americans or Jews. And the president of the University of Virginia was a member. And he was on the cover of Time magazine, and they asked him, how could he be a member of an exclusionary club like that? And he said he was fighting bigotry from the inside. You know, and I know that that's not something that you heard for the first time. It is, we haven't dealt with race very well at all in this country. And my own view is I've learned a lot in the last few months about what I didn't know, about some of the history that I think African Americans know very well because they lived it, and a lot of the rest of us didn't see it. You think I'm alone, Robert, on this, or do you think that a lot of eyes are opening up about the history of race and race?
Stephen, that is a very profound and acute, accurate assessment, I think, of where we are right now. There are a couple of things that I find encouraging in that regard. One of the other hats that I wear is president of the Leadership Council on Legal Diversity, which seeks to deal with the issue of leadership in the legal profession. And I am finding a much more concerned group of managing partners and general counsel who are younger, of a different generation, seeing a different outlook for this country and for the profession. Their concern requires a couple of things that go to some of Professor Steinhardt's observations. We can't play a game of rule of law or of masking we have got to be transparent and we've got to be intentional about our efforts if we're going to make any difference at all. And that's what I'm finding to be more the case with these leaders in our profession. They want to be more intentional about their approach, and they want to be more transparent about the outcomes they're trying to achieve. That is really the only way we're going to make any real progress. The other thing that I think is important is that just as Howard University made a very deliberate focus of training the next generation of civil rights attorneys, we've got to make it clear that in our capacity as leaders in the law, that we train the next generation of lawyers to understand, appreciate not only the history, Stephen, that you talked about, but understand the application of present tools to combat any issues of bias, as Judge Donnell indicated, and of promoting equality and inclusion as an essential pillar of any organization or societal effort in promoting civil society. Until we really understand the parameters of that, engage in dialogue like that, challenge each other as peers to promote equal justice, we will continue to find ourselves repeating the actions of the past instead of promoting new and innovative and creative ways of establishing a society based on the rule of law that is founded in dignity, respect, and recognizing the merits and contributions of those who come from different cultures, different races, different genders, different orientation, and the like. This is our challenge, and this is, to coin another phrase, it's on our watch. If we don't do it, it won't happen. And if it doesn't happen, we hamper and handcuff generations behind us to affect change and to raise the standard by which we understand the application of the rule of law.
Judge Donald, do you have a thought about whether we can do that? You have to unmute.
Robert, that was powerful and eloquent, and I would fully concur with you. I think that, Steve, it's not a matter of whether we can do that. I really think that we don't have an option. We must do that. I think that for too long we have been comfortable with this unspoken notion that there are disposable people in disposable places. But I think that we have to come to the realization that, everyone has value, everyone has dignity. That dignity must be respected. And in the justice system, people should not have to forfeit their humanity nor forfeit their dignity in order to get the full benefits of the rule of law. We have been talking forever about, those wonderful notions of equal justice and equal protection and equal access. And I won't say that we've honored them in the breach, because we really haven't honored those. Maybe we've said that some people are more entitled than others, but I think, as Robert said, the time is now for us to really work to make certain that we achieve those objectives, that we live up to our founding ideals. And we know our history. We know that there were certain folks who were not included in that, but we are a nation now that must embrace those and really include everybody in the orbit of that protection. And we must, those who have the ability and the responsibility for ensuring access and equality, we must hold each other accountable in that regard. I don't think we have options. We cannot move forward as a nation, fractured as we are, unless we fully embrace those and do everything we can, as Robert said, work with intentionality and a sense of deliberateness to move forward. We've got to do it. And I believe that we can't succeed and proceed if we don't. I think our history can be a springboard, or it can be a drag that holds us in place. And we have got to choose for that history to be a springboard.
Thank you. I'm going to close with a point I learned about dignity. When I was teaching at the University of Virginia, at one time or another, I represented every single prisoner in Virginia. In class actions, I represented people charged with first-degree murder. And I would say to each one of them, I didn't care what they were charged with or convicted of. I said, I will treat you with the same dignity as I would the President of the United States until you prove to me that you don't deserve it. Never one time did they disappoint me. They actually responded to that. It was like, it's the first time anybody's ever said that to me, presuming I'm an equal to everybody else. And I meant it. I said it to all of them. And what I want to end with is, so when I became a Deputy Assistant Attorney General in the Department of Justice, and Oliver North subpoenaed President Reagan and Vice President Bush, the Justice Department asked me to represent them as the government lawyer and quash their subpoenas. And I thought to myself, as I went over there and did it, that I'm going to treat the President and the Vice President with the same respect and dignity that I would any prisoner in Virginia. And I did. And I think we are actually out of time. And I want to thank all three of you. This was fabulous. And I'm really happy that you agreed to do it. And I know the criminal justice section joins me in giving the thanks.
Thank you.
A real pleasure.
Thank you so much. Great job, too.
Yes, great job.